Good afternoon. I'm Dean Horace Anderson, and I thank you for joining us for the 2026 Philip B. Blank Memorial Lecture on Attorney Ethics at the Elisabeth Haub School of Law at Pace University. I'm pleased to welcome today's speaker, Tyler Maulsby, Deputy Managing Partner at Frankfurt, Kurnit, Klein, and Selz. Mr. Maulsby will speak about the intersection of legal ethics and artificial intelligence and what the expanding use of AI means for lawyers, clients, courts, and the public. This is an especially timely topic. AI tools are increasingly being used to draft, research, summarize, and even advise. And that raises significant questions for our profession. How do we ensure competence, confidentiality, and candor in a rapidly changing technological landscape? How do we protect clients and the integrity of the legal system from the risks of misuse? And how do we think responsibly about regulation as legal technology evolves, particularly in ways that may affect access to affordable legal services? We are thrilled to have Tyler with us today to share his insights as we navigate this evolving landscape. This lecture, the Philip Blank Lecture, was established in 1990 by the family, friends, and colleagues of the late Philip B. Blank, Associate Dean for External Affairs and Professor of Law at Pace University School of Law. In honor of Dean Blank's commitment to legal ethics, the Blank Lecture has presented distinguished members of the legal community recognized for their leadership in attorney ethics and professional responsibility for more than 35 years. Today, Mr. Maulsby joins a long list of distinguished Blank lecturers, including Senior Justice on the Virginia Supreme Court Elizabeth Lacy, Robert J. Gray Jr., former president of the American Bar Association, and James B. Comey, former United States Attorney for the Southern District of New York. Mr. Maulsby, welcome. We're grateful to have you here, and we look forward to learning from you today. And now to officially introduce our speaker, I will turn it over to Professor Imre Seligy. Imre.
Thanks, Dean. Thanks. Thanks everyone for joining us today on this snow day. And before we get started, I'd like to share that if you have questions during the lecture, please feel free to submit your questions through the Q&A box. After the presentation's over, we'll have some time for questions, and I'll try to ask the questions that you submit. So during the presentation, please feel free to submit questions in that box. And so it's my great honor and privilege to introduce Tyler Maulsby today. I'm really excited about his presentation. It's such a timely topic, and I'm very grateful that he's here today. So his expertise is in the field of legal ethics, and he's the past president of the Association of Professional Responsibility Lawyers. He was the past chair of the New York City Bar Association's Committee on Legal Ethics, and currently he's co-chairing the New York City Bar Association's subcommittee on AI and legal ethics. He represents law firms and lawyers in connection with legal matters involving ethics, and he also is involved with commercial litigation and white-collar defense at his firm. He teaches the required legal ethics course at NYU, and he's also a graduate of NYU and Tulane Law School. So Tyler, thank you so much for being here today. I'm really grateful for you sharing your experiences and your wealth of knowledge with us, and I'll turn this over to you. Thank you. Thank you.
Thank you. Thank you for having me, and thank you everyone for pivoting to the virtual format. I think you can see me. I apologize, I cannot see you, but I will do my best to make this as engaging as I can in the virtual format. So I'm here to talk about the intersection of legal ethics and artificial intelligence. And to set that up, I want to make a pretty clear disclosure at the beginning, is that when I approach ethics rules and when we approach the ethics rules and thinking about something that is new and concrete, I think that we are new and innovative. I think we should approach it from a very straightforward place. And that's that when the ethics rules or the rules regulating the profession are rules of reason that are intended to set minimum standards for the profession. That is what is stated in the comments to the rules, and I think it should be taken very seriously. I think that is a very important concept, because while the rules often track concepts of fairness and of ethical behavior, they have to be applied within the framework of how legal services are actually delivered to clients and to the public, and how those services should be provided going forward. So what does that have to do with what I'm here to talk about today? Well, in my view, to answer the questions of how artificial intelligence has impacted the legal profession and how it intersects with legal ethics, we have to start with what the purpose of the rules of professional conduct are and how we should regulate the legal profession. So when we talk about regulating the legal profession, we're talking about two main things. The first is regulating who can engage in the practice of law, and the second is regulating the conduct of licensed lawyers. And that's an important distinction for reasons we're going to talk about. For the first, who can engage in the practice of law, that is mainly the subject of the unauthorized practice laws and statutes and rules throughout the country. And the second is largely governed by rules of professional conduct that are binding on licensed lawyers in the jurisdictions where they're practicing. So let's talk about both, because they both have a very important impact on how AI and generative AI intersects with the regulation of lawyers. So at the end of the day, the law is a licensed profession, and many of you have read it is a self-governing profession. There's some debate about whether that is true or not. It is not necessarily self-governing insofar as in many states, lawyers are regulated by the courts. We are not governed by ourselves, by other lawyers. But at the same time, most judges must be lawyers in order to take the bench. So in many respects, it is very much still a self-governing profession, and it is quite insular in that respect. All U.S. jurisdictions have laws that regulate the unauthorized and the unlicensed practice of law. But there's a very significant debate about what it means to practice law. In many countries, for example, the United Kingdom being one, the practice of law is limited to certain discrete tasks, such as appearing before a court or a tribunal, or the transfer of real property or some other officially recorded act with the government. However, in the United States, we take a much more expansive approach and attempt to also include, quote, legal advice in the definition of the practice of law. This is where it can get very tricky, because unlike appearing before a court, unlike filing a document with a government regulator, giving legal advice can be quite a nebulous concept. For example, if we rewind back to the 1960s, New York attempted to prohibit an individual who was not a lawyer named Norman Dacey from selling a book of forms titled How to Avoid Probate. Mr. Dacey was not a lawyer. Mr. Dacey was quite frustrated by the probate process that he had to go through himself, not himself, for a relative. And he decided that he wanted to help create a do-it-yourself guide for individuals who could buy the book of forms and then use the book of forms by filling out the forms and filing them in court, all without the help of a lawyer and all without having to go through the probate process. The New York County Lawyers Association did not like that very much, because they thought that whether and how to avoid probate was within the province of what lawyers did. And so they sued Mr. Dacey, claiming he was engaged in the unauthorized practice of law. And the case wound its way through the trial court, the appellate court, and ultimately up to the Court of Appeals. And for those of you who may not be New York lawyers listening, the Court of Appeals is our highest court. And the Court of Appeals ultimately said that providing access to legal information or forms in a book is not the practice of law, and that Mr. Dacey had a First Amendment right to do that. And from that case, we've seen what has become now generally accepted as the use and access to legal forms and legal information. Fast forward to the 1990s and the early 2000s, when companies such as LegalZoom, Rocket Lawyer, and others start providing more interactive forms and explanations to help guide the users through the forms. Because predictably, as technology evolves, the forms get smarter. And so there becomes a question of whether a form must be just a rote piece of paper with blanks that one can fill in, or whether it can be something electronically designed to have prompts and to help users and give users information about if they choose option A, this would be what may happen. If they choose option B, this is what that means, and whether that was the unauthorized practice of law. And there were several challenges in many states against these companies. And again, states ultimately began to use these interactive forms and accept the use of these interactive forms for the purpose of providing users with access to legal information is differentiated from legal advice. And these cases lay the groundwork for the smarter and faster legal technology that exists today. The forms keep getting smarter. So that's our UPL framework that we'll put a pin in for a second and then get back to. But then there's also something else, which is the other way we regulate the practice of law or legal services in this country, and that's the rules of professional conduct, right? The regulation on people who are in fact licensed lawyers. So the ethics rules are intended to be minimum standards for the profession. So what are the purposes of the rules? Well, they're mainly designed for three things: to protect clients, to protect the courts, and to protect the public. At bottom, the rules of professional conduct embody a lawyer's fiduciary obligation to the client. That is at the heart of many of the rules of professional conduct, and something that lawyers are assuming that Mr. Dacey in his Book of Forms was not, was a fiduciary obligation of trust and confidence with the client. The lawyer is aware of that and the client is aware of that, and that's the foundation of what forms an attorney-client relationship. The advice is important, the end product is important, but it's the trust and confidence that goes along with it that's the foundation of the attorney-client relationship. And we have a long history in our rules of professional conduct and of the model rules of professional conduct being changed to address technology. But the ethics rules can also be a barrier to innovation, as the rules also regulate how legal services can be delivered. So the most prominent example, which some of you may have read or seen more recently, is Rule 5.4 of the ABA model rules, which has been implemented in almost every jurisdiction with a few exceptions. Now, Rule 5.4 says that a lawyer is not allowed to allow someone who is not a lawyer, the rules call a non-lawyer, to interfere with the lawyer's independent professional judgment. But it also goes farther than that. It also has subsections that say that, quote, non-lawyers are not permitted to have an ownership interest in a law firm, and that a lawyer is not allowed to share a legal fee with a quote unquote non-lawyer. All of this, the drafters have said, is intended to protect a lawyer's independent professional judgment. That is the purpose of that rule. And while that goal may be correct and something that should continue to exist in the ethics rules, the question is whether the rule as written is actually carrying out that objective. And if you look at the history of Rule 5.4, it shows that it in fact was written as a protectionist rule designed to prohibit anyone but lawyer-owned law firms from providing legal services. There's an excellent article that was published last year by Nora Freeman Engstrom and Jane Stone called Auto Clubs and the Lost Origins of the Access to Justice Crisis. I encourage everyone to read it if they are interested in the evolution of the legal profession, access to legal services, and the access to justice gap that currently exists. But what that article tells us, and what is interesting about what I'm talking about here, is that Rule 5.4 came about, and many of the unauthorized practice of law statutes came about as a backlash to the auto clubs providing lawyers to their members. When I say the auto clubs, I mean AAA. Many of us probably have a AAA card in our wallet or in our phone. Those were the auto clubs. And back before the Great Depression, the auto clubs in the various jurisdictions had lawyers working for them. If a member got into an accident, the auto club would assign a lawyer to defend them and to carry out the lawsuit, and they were very good at it because that was all they did. And as economic times got more difficult, the organized bars began to see that this was actually a threat to solo practitioners' livelihoods and the livelihoods of some law firms. And so they began to lobby, whether it was legislatures or state bars, to change rules to prohibit non-lawyer owned entities from practicing law and providing legal services. And it shows that we have a history of keeping people out of the profession in the name of client protection. And while client protection is, of course, important and it's paramount, it should be addressed thoughtfully. And it should be addressed in the context of how do we also make sure that we are providing services to enough clients and not leaving many people behind. So why is AI different, right? When we talk about AI, it's important to differentiate between the sort of AI assists that have been around for years and generative AI, such as ChatGPT, Copilot, Gemini, and the like. The developments in generative AI is what I'd like to focus on here. So in terms of AI's impact on the legal profession, generative AI is different for at least two reasons. Number one, it has the potential to act far more independently than other AI-assisted tools. But the second, it's developing far faster than the regulations can react to. Gen AI is going well beyond just generating documents or analyzing large swaths of content. It's also providing opportunities for real-time interactive communications, and it's redefining how people get legal help. So it gives the legal profession an opportunity to re-examine whether we are regulating the right way and ask some very important questions. For example, what is the best way for lawyers to responsibly use generative AI while upholding the minimum standards of the profession? And second, how can generative AI help us reach currently underserved populations? So starting with the ethics rules. With respect to the rules of professional conduct, we would not have enough time to go through how each and every rule is impacted by generative AI, but we should discuss a few. So first and foremost is the duty of competence. Rule 1.1, duty of competence, requires lawyers to handle all matters with a reasonable degree of skill and competence. And again, the rules of professional conduct are minimum standards for the profession. They need to be interpreted accordingly. So does every lawyer need to be an expert in generative AI in order to represent their clients? Of course not. But at the same time, lawyers should not use tech or technology that they don't know how to use or what it does. This is very important for lawyers and law firms that are considering introducing generative AI products into their practice. It is important not only to understand what the product does, but also how the lawyer plans to use it and come up with a plan to implement it thoughtfully into their practice in order to make sure that the lawyer is upholding their duty of competence. The second is confidentiality. Generative AI raises some serious questions around a lawyer's duty of confidentiality. This is a rule that has been updated to account for technological developments. Rule 1.6 in New York's Rules of Professional Conduct and in most jurisdictions' Rules of Professional Conduct now contains either a rule or a comment that makes clear that a lawyer has an obligation to understand technological developments and to make sure that before using any certain type of technology in their practice, that they are upholding their duties of confidentiality under 1.6. And this does this in one of two ways. Number one, it requires lawyers to refrain from revealing client confidential information, but it also requires lawyers to prevent unauthorized access to confidential information. Now, with generative AI, this duty can cause friction with many of the Gen AI tools that are out there, which require training in order to improve. Put another way, the ideal technology tool being built by a technologist would love open access and feeding in as much information as possible so that the tool can learn. But at the same time, in order for that tool to be deployed into the marketplace, whether in the legal marketplace or another marketplace, there's a recognition that there have to be some walls set up so that the tool can learn to get better, but at the same time, the professionals who are using it are adhering to their confidentiality obligations. So when a lawyer is approaching a piece of Gen AI technology, Rule 16 requires the lawyers to ensure that they only use Gen AI in a way that does not disclose client confidential information, or to the extent they want to use Gen AI for client work, that there are adequate assurances that client confidential information will not be improperly stored, used, or disclosed. So the unfortunate thing is that this places a significant burden on lawyers, especially lawyers in small firms who are solo practitioners, who either have to rely on outside third parties that can be quite expensive in order to obtain this level of assurance, or to spend a lot of time scrutinizing the terms of service and trying to negotiate when there may not be sufficient leverage in order to get the protections that they need. And so this is something that I expect will work itself out over time. But right now, there is a pretty significant gap between, larger firms who are able to onboard or even create their own technology from scratch that implements Gen AI, and smaller law firms or solo practitioners who are sort of relying on the open market to see what is out there and having to do a lot of their own due diligence. Now, the other important piece under the ethics rules is the duty of supervision. Now, the supervision, there are 3 rules, 5.1 through 5.3, which talk about a law firm's duty of supervision, a lawyer's duty to supervise other lawyers that they oversee, and all lawyers' duty to supervise people who are not lawyers, or as the rules say, non-lawyers. And these are some of the most critical rules when dealing with generative AI, mostly because these rules highlight the challenge of navigating Gen AI across different generations. Law firms and supervisory lawyers have to ensure that all lawyers and non-lawyers are complying with the rules of professional conduct. That is the baseline standard. But the rules also acknowledge that the degree of supervision required depends on the level of seniority of the person being supervised and what is reasonable under the circumstances. So, for example, in a non-AI setting, a lawyer would have to exercise a much lighter degree of supervision over a career paralegal who has been doing the same job for 25 years than they would over a paralegal who may be right out of school and has only been working 1 or 2 years and has no subject matter familiarity. You can apply the same exact logic to supervising non-lawyers who are using Gen AI, because the lawyers who are supervising have to understand what the person's familiarity is with Gen AI, but also how to set up appropriate guardrails around the use of Gen AI products within a law firm to make sure that the work is properly done, it is properly reviewed, and that all ethical obligations are adhered to. So I started seeing this a few years ago in my practice, and now it's become more commonplace than in law firms and law offices. It is now prudent to adopt a Gen AI policy for how to use Gen AI, and also to help keep staff informed about the tools that are available and how to avoid people resorting to self-help. That in the early days of Gen AI, many firms would just prohibit the use. I can't tell you how many times I would see the sort of no chat GPT policy, which is fine. I have no problems with a no chat GPT policy, because if using a public sort of open source type program for confidential client work is of course unacceptable. But the firms that I think struggled a lot were the ones that sort of stopped at that, because at the end of the day, it is something that many people use, which we'll get into in a minute, and especially people of the younger generation. And so if you don't actually give opportunities to incorporate that into the practice, people will either leave and work somewhere at a more tech-forward firm, or they will sort of resort to self-help, which could create risks that a junior lawyer may not know. So it's important to actually have a thorough and well thought out policy, which, at this point is starting to become required under a lawyer's duty of supervision. Now, for the litigators out here, we also have a duty of candor. In litigated matters, we've seen issues with Gen AI play out on the public stage. We've seen the headlines of lawyers citing cases that Gen AI tools hallucinated. We've even seen examples of judges publishing opinions or releasing opinions, and it turned out that some of the cases did not exist. And when these cases were starting to come out, many people asked the question of whether the ethics rules and the court rules needed to be amended to address generative AI. On the ethics side, most of us said no, myself included. The first time I got the question, and this was not unique to me, many of my colleagues had the same reaction, we all thought back to the slew of opinions that still exist. You can look them up in New York State and elsewhere, which answered the question, can lawyers ethically use email while practicing law and complying with the rules of professional conduct? Of course, we can all now use email to comply with the rules of professional conduct. And frankly, lawyers if a lawyer does not use email in this day and age, it's going to be very difficult to practice law and to comply with the duty of competence, including the technological duty of competence. But it demonstrates the same question, right? As new technology evolves, do we need to change the rules, or do the rules we have serve the purpose we need, and they just need to be modified a little bit in order to address the new way of practicing law? And we also saw courts adopt rules requiring disclosure of generative AI and as some kind of safeguard. And many people, again, myself included, said that doesn't make sense. I personally do not think that a court needs a specific rule that requires disclosure of the use of Gen AI in a brief, or that prohibits it or requires some other safeguard. And the reason is, again, you have to ask yourself, what is the purpose of the rule that's being created? We've seen many cases where lawyers have misused generative AI in legal filings. And in none of those decisions, or at least none that I'm aware of, has any judge struggled to find a legal basis to impose sanctions where it is necessary. In the federal courts, Rule 11 is alive and well, right? And a lawyer ultimately still bears the final responsibility for the truth and accuracy of anything that the lawyer submits to the court. And second, any rule that one writes in a specific jurisdiction that requires disclosure of the use of generative AI is going to be obsolete by the time it is actually enacted. And that's because, again, the technology is still developing, but it's really impossible to write such a rule that's not so overbroad that it's meaningless. Because, I think we can agree that just disclosing this law firm used generative AI in some capacity with respect to this brief is so vague that no one can know what it means. But at the same time, it could be seen as some type of, even if subconscious, credibility knock on the filing when that's not in fact appropriate. For example, a law firm using a bespoke tool that they have created and curated, and then the brief is still vetted and reviewed and approved by multiple levels of associates and partners, is not the same as somebody putting a query into ChatGPT, asking ChatGPT to write you a brief, and then pasting it without review. But if the same disclosure is required, it starts to become meaningless. And so it really goes back to those fundamental questions, right? Of what is the purpose of these rules, and how are we trying to regulate the legal profession? All of these rules and cases evidence the court's deep concern with whether the information being put in front of them is accurate and reliable, but it still leads to the question of how do we best regulate our profession in order to accomplish those three purposes I said before: to protect clients, to protect the courts, and to protect public confidence in the legal profession, or to further public confidence in the legal profession. Now, the other place where generative AI has made a significant impact is on the price of legal services. And we have a Rule 15, about fees, right? And fees must be reasonable. And there's a whole question about what is a reasonable legal fee. And for much of the market, approximately 80%, if not more, of fees are billed by the hour. Obviously, lawyers cannot charge for work they didn't do, and clients will not pay for hours of work that can be accomplished in minutes. For example, at the beginning of the Gen AI boom, I started personally seeing outside counsel guidelines, which are, instead of an engagement letter, large corporate clients and insurance companies may have a whole sort of volume of things that their lawyers can and can't do and what they will and will not pay for. These are called outside counsel guidelines. And I started seeing outside counsel guidelines that says you cannot use generative AI because we can't trust the reliability and we don't like the security risks. Fine. Fast forward, it was probably less than a year, I started seeing outside counsel guidelines mandating the use of generative AI because it started to become more reliable. And of course, the client appreciated the cost savings and did not want to pay for 10 hours of work when it could be accomplished in 1 hour. And so we are seeing generative AI take a significant impact on how legal services are priced. But it really leads to the question of, does that impact the value of the legal services or just the amount of time it takes? Because going back to, again, this fiduciary relationship that we're talking about and the entire purpose of the attorney-client relationship, often clients are not paying for the time so much as they're paying for the answer and the skill and the expertise of the lawyer and the reputation of that lawyer so that they can rely on that response. It is not simply the product that is coming, the output that is coming out, so much as it is the value of that relationship and the value of who is providing the service that the client is paying for. And Rule 15 discusses various factors for what it means to be a reasonable fee. And one of those is a fee that is customarily charged for the type of service. I expect we may start to see far more creative fee structures as generative AI is baked into legal services. So instead of straight hourly fees, you may start to see flat fees or structured fees where representation has various phases, or for ongoing work, especially lawyers and law firms that may provide sort of outside general counsel work, you may start to see more of a sort of license fee model or a subscription fee model. And all of these are going to need to be justified by Rule 1.5a. And it also leads to the question of, do we need to redefine or slightly alter what a reasonable legal fee is as defined in the rules? So before somebody asks the question, is this going to be the death of the billable hour? I think it probably will not. I think the billable hour has its place, but I think looking at the history of the billable hour and where it came from, it's important to know that it is not the end all and be all. I think we think that the billable hour is largely something that has been around since the beginning of the legal profession, and in fact hasn't been. It hasn't been. It was, created at the beginning of the history. It was created at the beginning of the 1900s, actually by a legal aid lawyer in Boston, and it was very slowly developed over time, or slowly adopted over time by some of the largest law firms, with many of the sort of oldest law firms resisting it because they did not like this concept of billing by the hour. So I think that that's important to keep in mind in terms of, this is not the first time that we have asked the question of how should we be pricing legal services and what is the best way to make sure that clients are still treated fairly and that we don't have unethical charges or unethical billing, whether that's hourly or some other way, while also giving lawyers the flexibility to price the legal services by something other than just the sheer time it takes to do the task. And the last piece, which I alluded to earlier under the ethics rules, that's important to talk about is the non-lawyer ownership piece. You may have seen, and they certainly exist and they are growing, these native AI law firms or AI native law firms, right? And these are law firms that are powered largely by AI. And this is where, whether it's here or in another context, this is where this idea of non-lawyer ownership is very prominent, because while our legal education was worth every dollar we paid for it, it also did not prepare us to do every single thing under the sun. It did not, we typically do not learn in law school how to run a multi-million-dollar business. We typically do not learn how to run a tech company in law school. These are skills that other people went to school for, trained for, have decided they are very good at. But when you have just an outright prohibition on allowing people with other skill sets to have any kind of ownership role in a law firm or any type of financial interest in a law firm, it makes it rather undesirable for them to enter into the legal services industry. And so it makes it very difficult to attract talent. And so there are ways to deal with this, and there are ways that people have been experimenting to deal with this, but it is all in response to a sort of currently outright prohibition on people who are not lawyers having really any high-scale involvement in running or owning a law firm, even if there was such a rule, which exists in certain states here and in other countries, that would prohibit non-lawyers from still interfering with the independent professional judgment of the lawyers. So this is something where we're seeing a great deal of development as well. Now, finally, moving on from the ethics rules into the unauthorized practice rules, or the UPL laws. Now, as I mentioned earlier, the ethics rules are only relevant when we're talking about lawyers using generative AI, right? But what about people who aren't lawyers using generative AI? There's an entire segment of the legal industry that involves non-lawyers providing what I'll call legal help or legal information without the assistance of lawyers. And this is regulated largely by the unauthorized practice of law. At present, and as Dean Anderson mentioned, individuals and small businesses are now turning to these general purpose Gen AI tools, again, ChatGPT, Gemini, Copilot, etc., tools designed for widespread public use. People are turning to these general purpose tools, as well as certain specific Gen AI tools that are aimed at providing legal help to address everyday legal needs. Individuals, small businesses use these self-help tools because they may not be able to afford a lawyer, or because they don't want to hire a lawyer, or because they think they don't need a lawyer to address the issue they face. The study recently put out by the New York State Bar House of Delegates found that as of mid-2025, even among lawyers, ChatGPT was the most commonly used AI tool, while legal specific platforms saw minimal adoption. AI can also help us address the ongoing access to justice crisis. What these reports show is that there is already widespread use. That is not something the legal profession has to take on, nor is it something that the legal profession is really going to be able to change. The generative AI general purpose tools are out there, and as of at least right now, they are not going anywhere. But you have to take that and contrast it with the long recognized scarcity of lawyers in underserved communities that has long resulted in an access to justice crisis across the state and country. Now, many people in that space believe that that can be alleviated by putting the appropriate Gen AI tools directly into the hands of nonprofit organizations or the public. There are numerous bodies out there that have studied this, including the National Center for State Courts, which has published several papers on this. But that is the future, not the only be all and end all, but that is the future of pursuing access to justice, is how can Gen AI tools help existing legal service organizations, new legal service organizations, and how can they responsibly be put in the hands of people who need legal help the most? The access to justice gap is real. It is well known. Just in New York alone, as of 2024, from a report that the New York State Court's Permanent Commission on Access to Justice put out, 75% of low-income households report that they have at least one civil legal problem each year. 40% report experiencing more than 5 each year. 25% of those people have attempted to ask for legal help, and only half of that 25% are able to find it. This has put the legal industry at a crossroads. We could stick to existing laws that are designed to keep non-lawyers out of the legal industry and try to send Gen AI tools the route of the auto clubs. Or we can craft responsible legislation that allows Gen AI to provide legal help and information in a way that expands access to justice while also implementing responsible guardrails. On the first option, option A, right, which would require, if we actually want to solve the access to justice gap, would require deploying that many lawyers to make up for that. Just to provide additional lawyers through legal service providers in New York alone to close that gap, it would cost approximately $1 billion a year. That is New York, only New York. So we also have to acknowledge the current landscape of the accessibility of these tools that can give legal help without formalizing what I'd referred to earlier as sort of a full-fledged attorney-client relationship. Because what's inherent in the use of a lot of these tools is that the user generally does not believe that they are getting the advice of a lawyer. They're getting the advice of a generative AI, whether it's a chatbot or something else. But we have to acknowledge the current landscape, that there's no practical way to prevent the use of generative AI to provide legal assistance. And there frankly aren't very good reasons why the public should be prohibited from using a tool that offers some degree of legal information that may produce better results than sort of a conventional do-it-yourself research or guessing what the answers are. And when proceeding without a lawyer's assistance because they either cannot find or cannot afford a lawyer. But the current UPL landscape creates significant uncertainty for providers who are interested in entering the marketplace. Specifically, the current landscape, which prohibits the rendering of legal advice and counsel in New York, raises questions about whether such tools are in fact engaged in the practice of law or doing something else. So, you have to imagine for a second from the point of view of the provider, someone who wants to create a Gen AI powered tool to help self-represented litigants. That person would need to go out, they need to get funding, they need to raise money in order to build the tool, they'd have to deploy it. And just on the founder level, it's very difficult to do that when knowing at any given time your entire business could be declared illegal, let alone a willingness to invest in a tool like that. And so the current unauthorized practice laws and the history of enforcement that we talked about earlier gives founders significant pause as to whether to enter the legal services space, notwithstanding the need that we just talked about. And so, in my view, states would be well suited to explore changes to their UPL laws that would allow for innovation and responsible growth instead of opting for an outright prohibition and sort of legislating reactively. We've seen this so far in Texas, which has amended its unauthorized practice law to carve out from the practice of law the creation or publication, distribution, display, sale of books, forms, computer software, or similar products that clearly and conspicuously state that the products are not a substitute for an attorney. So these products, whether electronic or hard copy or some other software-powered product, that clearly and conspicuously states that the products are not the substitute for the advice of an attorney. And the history behind the Texas legislation is that Texas was one of the states we talked about earlier that attempted to enforce against many of these electronic form providers and was unsuccessful. And so it amended its legislation. Now, in New York, I'm part of the subcommittee, task force subcommittee I co-chair. We are talking about and are very close to recommending a change to New York's unauthorized practice law, which would have a similar carve out. And not only, in our view, would this open the door for more legal services to be provided to the public at affordable rates, but most importantly, it also changes the focus of regulation. It will always be difficult to define the practice of law. And what the Texas legislation does, and that section I just quoted twice for you, is that it shifts the focus of the inquiry from the actions being taken, right? Whether something is legal advice or information, to the understanding of the consumer, right? Whether it is a advice or whether it is information that is being given by a book of forms or a human or a lawyer, it's the understanding of the consumer, whether they understand that what they are getting is the advice of a lawyer or what they are getting is information by something that is not a lawyer and that is not, intended to be legal advice, but is simply a substitute for access to legal information. And it makes it quite a bit easier to regulate in that respect because you can tell based on the circumstances most times what either the intent was towards the consumer, right? Was it intended to mislead the consumer, or what the consumer genuinely believed. And so currently there's a significant amount of uncertainty, but I'll conclude by saying that I believe we know two things right now. Number one is that the current state of the legal market is largely underserved. And that has been a problem that is only continuing to grow. But second, if the goal is to provide legal services to more people, and I believe that it should be, then the profession would be well served to embrace technological developments and regulate responsibly instead of doing it reactively, and to embrace these developments and find a way to reach more people in a responsible way. So with that, I want to say thank you. I believe there may be questions, and I'm happy to answer any questions.
Well, thanks so much, Tyler. Thank you so much. And just want to remind the attendees, if you have any questions, please submit them in the question and answer box, and we'll get to them. And so, Tyler, thank you so much. It was so informative. You covered so many different topics of legal ethics, from confidentiality to fees to just non-lawyer ownership of firms. I wanted to touch upon UPL, unauthorized practice of law, for a second. Every state, I believe, has some law making it a crime to practice law without a license or to assist someone else in the unauthorized practice. And I'm glad you mentioned the Texas example, the Texas statute. I think that is the ideal solution. So a software provider would basically have immunity from the unauthorized practice of law accusations if they had that strong disclaimer. I was wondering, and several states decades ago were very aggressive investigating LegalZoom and other providers of software. Have you heard of any states investigating providers of AI tools or generative AI? Or I'm concerned now that if a law firm provides an AI tool for one of its clients, they're at the risk of assisting a non-lawyer with the unauthorized practice. So have you heard of any recent waves of investigations from state bars?
I've not heard of any recent waves of UPL investigations about sort of large-scale Gen AI tools. The investigations, and they're not necessarily about the AI component, it really is more about the sort of consumer, they're the fringe cases where someone's doing something that is clearly illegal, right? Like you're making it seem like someone is chatting with a lawyer when in fact they're not chatting with a lawyer, right? Something like that. I think that the regulators have taken a little bit more of a wait and see approach. But I mean, what I usually, when I get this question from clients who are looking into the space, I sort of, I say it this way: there are three places generally that a regulatory complaint, that a regulatory issue can come from, right? Number one is a regulator just looking at it and saying, I'd like to know more here, and that's certainly possible. And there are certain jurisdictions where they have far more active unauthorized practice or UPL committees than other. New York is not an active UPL state, but for example, Texas, California, Florida are. So that's number one. The second is client disputes, right, where it's raised in the course of a litigation with a client, where they say, well, this service is impermissible and you violated unauthorized practice, so I don't have to pay, right? And then it's in the hands of the court. The court can decide to take it up or not, depending on the procedural rules and what the merits are. But then that can also be referred to a regulator. And the third is sort of the either competitor complaints or the people who may just fundamentally disagree with having Gen AI provider in the legal space, right? And those can be sort of interested third party complaints. If I had to make a prediction, right, like as the space becomes more developed, I can see competitors wanting to sort of police bad actors, right? There's a history of that in other industries. So right now I have not, but I expect we will at some point.
Oh, thanks. Thanks. Some questions from the audience. One question is, how do you think the ABA model rules or legal ethics in general, how do you think the ABA model rules could support or address concerns about the environmental impacts of generative AI? Like, could there be a legal duty that could address these concerns?
So it's an interesting question. And I profess I don't know. I know there is an environmental impact, just the degree to which I don't know. I think that we dealt with this with the city bar, not on this task force, but in another context years ago. And I think that one area where a lawyer, could have a duty, and they're not going to get disciplined for it, right? But it's more, we have a few rules that are more advisory, right? Things that lawyers should keep in mind is our obligations, in Rule 2.1, which is model rule in New York, right? Which talks about that a lawyer is also an advisor, right? And as an advisor, they should also consider and raise with the client any other considerations, social, moral, ethical, etc., that may go along with this, right? And so I think there it could come up, but I also think, it'd be very fact specific, but if a lawyer believes that something they're working on or something, you know, makes too much of an environmental impact, right? And this would be more about the tool and not the sort of macro issue as a whole. They can either say we're not going to use it for that reason, right? Similar to how a law firm may say, like, we're going to do this for our environmental initiative. But, also that, that they, if they're that uncomfortable, Rule 116 would allow them to withdraw.
Yeah, yeah. I think that's a great point. You mentioned Rule 2.1, and I think at the very beginning of your presentation, you framed the ethics rules perfectly. Something I think we easily miss, that the ethics rules are bare minimums, right? They're just rules of reason. And so the rules do allow for us, like you point out, we can address concerns beyond the narrow legal claims, but we can address concerns about politics, society, environmental concerns, economic concerns. And so that room is there, but I don't think it's it's mandated by the rules. There's another question from the audience. Do you think that generative AI use in firms can affect client trust in lawyers? Or do you find that clients prefer lawyers that use generative AI more? The trust issue.
I will give the classic lawyer answer. It depends. No, I mean, look, I think ultimately it really does depend, right? I mean, so for example, if a lawyer if a lawyer uses AI to a material extent and does not tell the client they did that and the client expected something else, I think, yeah, that would cause trust issues. Similar to if a lawyer misused AI, that would, of course, cause trust issues. I think if a client, if it either doesn't make a difference, right, because it's not a material, use of AI, or the client expects it based on who the lawyer is, the type of firm they've hired, and all of that, then no, I don't think it causes trust issues because it's just, it's what the client expects. But I think, there's one piece we didn't talk about because we didn't have time, but one of the other big areas of, ethics in generative AI is the duty of communication, right? And lawyers have to communicate material developments to clients under Rule 1.4. And so it raises this question of, well, when is the use of generative AI material, right? If I have it do a first draft of a brief or summarize some research, probably not material. But, if I'm, really relying on it and budgeting my day based on how much time I have and I'm going to use AI for these things, and then something goes wrong, that may be material, right? And so it certainly can. And so I encourage lawyers always to sort of have the AI conversation. I've seen big firm lawyers put it in their sort of terms and conditions of their representation. It's a good conversation to have because unlike email, the tech is not generally accepted yet, right? It's still evolving.
Thanks. Thanks. There's another question. This has to do with disclosure. To what extent must an expert witness disclose their use of AI?
It's going to depend on the court rules. And I mean, I assume an expert witness in a court. I think it's going to depend on the court rules, right? I'd look there first. I don't, yeah, I mean, I'd have to look. I think it would depend on the court rules and the sort of procedural rules, right? Is it something that would be material to the report under, so for example, Rule 26, right? Is it something that would be relevant in Daubert, right? Like if it's Daubert challenge. I think it's certainly fair game, right? Depending on what the subject matter of the expert is. Like if it's an ethics expert, I'm not sure. Like if someone hired me to be an expert witness, I'm not sure why anyone would care whether I used, Westlaw's AI powered research or, use Boolean search terms. But like, yeah, I think an expert who is doing more scientific work, right? The scientific analysis, I can certainly see it being relevant depending on the circumstances.
Another question. Can you recommend, are there any resources or like just well-known reports dealing with the use of AI and legal ethics? Like if there's a resource that we're trying to do some research on this field, can you make any recommendations, like any place we can look to for best practices or best policies for a firm to adopt? This may be
So,
too early. I don't know if it exists yet, but
well, I think the best thing, because it can lead you in different directions. I'd encourage everyone to go to the City Bar Task Force's subpage on the City Bar's website and go to the ethics section, the ethics subcommittee. We have, and it was, I think, I just finished updating it again like yesterday, so I'm not sure it was published yet, but we have just a comprehensive resource by state of all the AI resources that have been published, right? So like
wow.
you'll get links from there to, New York has a couple, Illinois has done one, Alaska did one, so like you can see those, but I would start with the City Bars Task Force website.
Okay. And are there any tasks within a law firm that you would say, AI is ideal for, like just getting some legal skills, legal tasks? What have been the best uses of AI that you've seen so far?
That are developed, I would say analysis, right? Like either initial analysis of, like I think in the right circumstances, it's really helpful to just as a spot check, right, or as a backup, like run the briefs through to see like, am I focusing on the right cases? Like sort of objectively, what does the computer think is happening, right? Don't use it as a substitute, but it's helpful to supplement that. I've seen it in the sort of day to day, like help with sort of sanitizing communication, like helping with communication, right? Like if you're trying to write an email and you can't like figure out the way that can be helpful. One thing I would say, this isn't really the practice of law, but we all do it, is PowerPoints. Like that is very rudimentary, but that's one thing that's certainly helpful. But I mean, I think that one of the things that AI can help with when it's properly onboarded is synthesizing and analyzing and finding so much information that's in a law firm that may not be well kept, and helping to gather all that. I think there's certainly more ways that it can be used. as the tech evolves, but that's, some that I think are safe and responsible now.
Well, thank you, Tyler. I think unfortunately we're out of time. I want to say thank you so much for an informative presentation. I'm really grateful you took this time to share with us. Just thank you. Thank you for a wonderful presentation.
Thank you for
Thanks
having me.
everyone for joining. Thank you.